visit our website at canbar.org. And without further ado, I'm going to go ahead and pass this over to Jason Moscovici to open up our webinar for this morning. Jason, take us away.
Perfect. Thank you very much, Chris. And it's interesting that you mentioned this morning, because it's this morning for you and those who are on the West Coast. It's this afternoon for those who are on the East Coast, and it's this evening for those who are tuning in from Europe. So great, it's great to have everybody, and honestly, really looking forward to this chat that we're about to have. In terms of introductions, for those I haven't had the opportunity to meet yet, I'm Jason Moscovici. I'm a partner at a firm called Robic, based out of Quebec, Canada. I run their cannabis practice group. Robic's a full-service intellectual property firm, and we've been providing specific services to the cannabis industry since 2013. Why is that? Well, because Canada had a regulatory framework in place since 2013 to basically incorporate the cannabis industry into lawful commerce for the therapeutic space first, and then for adult use in 2018. But we'll get into that a little bit later. So I'm moderating this panel. I'm also an untrustworthy moderator because I'm going to be providing the Canadian perspective where necessary as well. Okay, and what we're going to do today is what I hope is one of many, chats that focuses on intellectual property in cannabis, because really, as the markets open and as we look to a harmonized approach to, I guess the cannabis industry and trading in the cannabis industry, intellectual property is really one of the first forms of, I guess, good that the industry can transact it. Okay, at least that was the experience that we had up in Canada when things started to stabilize and we had a federally legal market. Companies basically developed know-how, developed brands, innovated, and then were looking to expand as they do, and that brought them and us in parallel into trying to see what the moving parts were with the rest of the international market. And as we learn, because something is federally legal in one country doesn't mean that it benefits from the same rights in another, where lawful commerce is still an issue. Okay, so that brought someone like myself to enter into conversations with experts from around the world, and those who are joining us on this panel today are those who I've also had had the pleasure of either chatting with or been recommended for such conversations, and who have lived through the same issues. So that's when we've reserved 90 minutes to kind of go over and maybe even just spill our hearts in terms of some of the lessons learned when it came to managing and prosecuting IP portfolios and transacting and also litigating. So what I want to mention also is that this is not a traditional presentation in the sense that it's a fly on the wall conversation. We put ourselves in the perspective of either listening in on a conversation between longstanding IP colleagues who have thrown their hat in the cannabis industry with look to support and provide services to the cannabis industry, but also let's postulate a hypothesis. Let's say there's a Canadian licensed producer who's looking to expand. They have IP that they believe should be protected in many jurisdictions. That includes innovation in terms of plant science, procedures for extractions, lighting, and so on. They have brands that they've been used to sell products that are issued from these techniques and this innovation. And they're saying, well, okay, we want a dream team of people to be able to hypothesize as to what's the best way for us to move forward with developing a portfolio, transacting with it, and enforcing it, which brings us to the conversation that we're going to have today. Okay, and I say this is one of many because we have practitioners right now that specialize in different forms of IP across the board. We have patent agents, we have attorneys that specialize in trademarks, we have litigation specialists. So the idea is to break down barriers, break down the silos, to have sort of a first approach at a team conversation to try and say, what's the best way we can serve this hypothetical client and sort of take it from there. So hopefully this is one of many, and that the format is something that's suitable for the subject matter. So I'm going to stop blabbing and start introducing the rest of the moving parts of this, and then we'll get into the chat. So going at this in a completely non-selective, there's really no completely random fashion. Nicole Katzen, why don't you start? Why don't you introduce yourself to everyone?
All right. Hello, everyone. I'm Nicole Katzen. I'm an attorney with Evoke Law. We are based in San Francisco, California. My practice primarily focuses on trademark clearance, prosecution, and enforcement, but I also counsel on additional consumer protection matters, such as California packaging and labeling requirements, product recall plans, and also the advertising and marketing regulations for cannabis operators. That's my general spiel about myself.
Perfect. Hi, Nicole. Let's bring it to Mr. Juan Luis Serrano.
Hi, everyone. For those of you I haven't met, I'm Juan Serrano. I'm an attorney, a Mexican attorney. I'm a partner in a full-service law firm called Santos Giovanni, where I oversee both the life sciences practice and the IP practice. We do IP services across the board. We do a lot of life sciences related regulatory advisory and litigation, and we have dabbled to some extent on cannabis as to what's been allowed under Mexican laws, where we don't still have full legalization, but we have had incursions on IP issues here. So glad to join the panel.
I know probably the INCBA is going to write me a message if I don't mention it, but Juan Luis and myself, we co-chair the international committee of the INCBA. So to members out there, potential members who are looking to contribute to the international community and enter into the conversation with regards to providing cannabis legal services, please reach out, and we'd be happy to include you. So moving along, Mrs. Margaret Knitter.
Yes, hi. Thanks, Jason, for inviting me in this round. I'm very excited. I'm a German lawyer. I work at the German law firm SKW Schwarz. We are one of the largest business law firms in Germany. We have 130 lawyers. I'm heading our cannabis law group, and my main focus is IP. So that's trademarks and design protection. I do both prosecution and enforcement. I also do advertisement law and regulatory questions. I'm handling especially with regard to cannabis matters. Yeah, that'll be it.
Perfect. Thank you. And Dr. Jayashree Mitra, why don't you introduce yourself?
Hi, everyone. I'm better known as Jay, so that should help. I work at the full service law firm of Fox Rothschild. I'm based out of the New York office. I'm a partner here. My relationship with cannabis goes back long before I became a lawyer. I used to be a research scientist, and I did work on the effects of prenatal cocaine on the developing brain. What I focus on is litigation, enforcement, defense, and also advising clients on building their patent portfolios, keeping in mind what are the considerations they will face when they're seeking either to monetize their portfolio or they're trying to defend their portfolio, and not just in the United States, but to think globally, because this is an industry that's not confined to a single country. And it's a pleasure to be here. Thank you all for joining in.
Thank you. And last but not least, Dr. Marcelo Pomerantz.
Hi, everyone. Thanks again for having me on the panel. My name is Marcelo Pomerantz. I'm a senior associate at Cooley LLP. Full service law firm. We have about 1,500 attorneys. Very much a life science focused, and also all things IP and also all things venture capitalists, funding and IPO. I've been working in the cannabis space since about 2013, prosecuting patents, not just in the United States, but in Canada, Europe, and Mexico. So I'm hoping that I can bring some of that experience and also the comparative sort of legal frameworks under which we worked to this panel. And I look forward to chatting with all you guys and also learning from the other panelists.
Perfect. So great. These are the cast of characters have been introduced. So why don't we get into the conversation? So I'll start with Canada just to introduce a premise, and then we'll expand from there. So we have legislation that makes it such that cannabis is federally regulated. So engaging in cannabis such that you meet the requirements is lawful. That means that tools that have been used by traditional commerce are now available to the, or not now, but are available to the cannabis industry. So what comes with that is intellectual property legislation, trademarks, patents, industrial design, plant breeder rights, and so on. These are terms that are Canadianized, but you can make the relevant sort of permutations. When I talk about plant breeder rights, we're talking about plant variety protection in other jurisdictions and so on. So the issue for us at the beginning wasn't so much the ability to obtain intellectual property rights. It was more on the prosecution side. So I'll give an example. If we were to file a trademark that would cover a cannabis product and service, you would pretty much automatically get an examiner's report, basically asking for more information about the cannabis product or cannabis service, because the examiner at the time had no idea, really had no comparable. Okay, so what ended up transpiring from that was, when you look at subsequent applications and registrations, is you had no uniformity when it came to how these products and services were described. You'd look at one application and compare it to another, and it would be kind of night and day in terms of terminology, the conventions that were used, and so on. And the reason why that creates a bit of an issue is because, let's say you're in a traditional industry, so you're in the food business, and you have someone in the cannabis business who's applying for an edible form of cannabis product. You want to know if you oppose or not. You want to know if this, presuming that the trademark causes confusion or is likely to cause confusion. You're in traditional industry. Cannabis is a regulated space, and there was an ongoing conversation as to what is that wiggle room, what is the gray area, what is the friction point between traditional industry and the cannabis industry, because of this sort of lack, not only because, but principally due to this lack of uniformity into how in the different categories they were being described. In parallel, when it came to seeking patent protection, Canada is a market. It's not the biggest market. Canada is normally an accessory market to other industries. So people usually file in the US, consider filing in Canada and elsewhere. In Canada, particularly because of the lawful commerce thing, we became an interesting jurisdiction, because by virtue of the fact that we pretty much already had a monopoly, because you could really only market in Canada federally without incurring certain risks. Okay. And that brought additional prosecution challenges as well, because if we have filers who weren't using the international system, weren't benefiting from priority dates, the whole prior art issue, how do you then manage a client that looks at Canada first and then wants to grow and expand worldwide after? Okay, and that brought us to having conversations with practitioners in other jurisdictions to try and manage this. For example, the US, if we were to file a trademark application in Canada and want to use it as a priority filing for the United States, doesn't really happen the same way, because there's our products and services that are listed that it appears are not lawful commerce in the United States, and therefore from a federal perspective can't benefit from registration. So these are some of the issues that we started to kind of see and sort of butt heads with and try to understand, because we were creating two parallel or distinct markets. All right. So now that we're all together and that we have, again, this hypothetical client that I was talking about indirectly before, has brands that it's seeking to protect and at least the United States, Mexico, and Germany, has what it believes is some know-how and innovation that it's looking to protect as it concerns its plant-based science, as well as anything, its extraction techniques and so on. What's the best way for us to serve this client, and what can we recommend in terms of the lessons that we've already learned? Okay, so we ended with Marcello in the introductions. I think I'm going to prompt him first as it concerns, because he had mentioned patent prosecution since 2013 in Mexico, Canada, and the United States. You have a client based in Canada, hasn't made a filing yet, has what it thinks is an innovative again approach to a plant, and also believes it has an extraction technology that's related to this plant. What's the first thing that you want to know from this client in terms of trying to establish a filing strategy, or how do you approach this client in terms of the first things you want to tell him or her?
Well, so thank you, Jason. I think an important first step is to understand that there are many ways to protect an invention. So people will often reach out, and I think the most immediately recognizable form of protection is the utility patent. People are naturally drawn to it, but it's important to recognize that there's other forms of protection, including, of course, trade secrets. And there's a whole discussion that can take place in terms of what are the pros and cons versus keeping something sort of in-house, private, versus seeking a legal monopoly by seeking some sort of formal protection. If there's a decision to seek formal protection, depending on what the invention is, there's several different avenues or different forms that you can get a monopoly on. The first is the utility patent, of course, which people are familiar with, where you craft your own claims. You can define sort of the invention. There's a lot of flexibility in the subject matter that can be covered, which also includes plants themselves. People are often confused and they think that plants are not patentable, but also methods of extraction, as you mentioned, devices, all kinds of things can be claimed. If we're talking very specifically about a plant invention, and you mentioned that there might be some kind of genetics here, not only do you have access to the utility patent, but you also, in the United States, have two additional forms of protection available to you. One is the plant patent, which is very unique to the United States. It is also prosecuted by the US Patent and Trademark Office. Prosecution follows very similar to utility. The difference is that plant patents are very unique and specific to plants. The claims are unimaginative, and it is to the plant described herein. And you get protection only against the asexual reproduction of the plant, but it is an option. And there are some differences in how you would prosecute and the types of submissions you would have to make. And additionally, if we're talking about plants, not only in the United States, but also in most countries around the world, you have the ability of seeking plant variety protection, which is not usually prosecuted by the patent office, but rather by the agricultural office in the United States. The USDA manages it. And again, it gives you protection for the variety itself. There's some exceptions on the coverage. Specifically, there's a research exemption in most other countries where, and a breeder's exception, where that protection has exclusions where, for example, a farmer can save seed for the next year or can breed with it. There is a chart that I'll just briefly put up when we discuss that, just so that we have something to reference. So now that we have the options available, let's talk about what you would want to pursue and what are the differences very specifically. So utility patent, again, you can seek protection for anything you want. You can define it in the claims. If we're talking very specifically about a plant, there are two things that you would have to be aware of. One is that there are judicial exceptions to patent protection. And the most relevant one here for the purposes of our discussion as it relates to a plant is the natural phenomena or natural products. So if this is a plant that they just found on the street somewhere, then it would be considered natural, not found in the street, found in a field that was not cultivated, did not actually produce it via intervention. It would be considered judicial exception and likely not patentable. The other thing that to be aware of is that if we're talking about seeking protection for a specific plant, you need to find a way to enable the invention and also to define the invention. And barring having some kind of genetic information that really defines the plant, like a genetic trait that you introduced, you would need to provide and define the plant through a biological deposit. So this is something that's a little bit unexpected to clients when I speak with them, in that you physically have to get your seed or your tissue, put it at an international depository or an internationally approved depository. It doesn't necessarily have to be outside of the country to enable your invention. That has some consequences. That deposit will become available, not just in the country where you have patent protection, but also outside once your patent issues. So it's something very important to keep in mind. And there's also some timing requirements in terms of getting a priority date, in that in the United States, you're able to make a deposit later during prosecution. But if you plan on seeking international protection, you would have to have any strength to that priority date, include the deposit very early on. And this can take some time, and it's something that we can discuss in more detail for anyone that's interested. The plant patent, in contrast, requires no deposit whatsoever. It's purely based on descriptions of the plant. These can be very intensive and detailed, in that you would be surprised. There's huge charts that we keep on what the USPTO requires. And they even want to know the angle of the pedicel of the third leaf, the leaf hairs. It's really quite surprising, and sometimes a frustration to clients who think that plant patent is going to be an easy path. Sometimes it can actually be a little bit more complicated. The difference here, again, I just pointed out, is that plant patents only protect against asexual reproduction, meaning that if your plant is propagated via seed, plant patents may not be the best option for you. And finally, plant variety protection. There's also a deposit required, although the USDA is working on a deposit holiday right now. There's one other distinction as it relates specifically to the US market here, in that because the deposits are placed in a federal seed bank managed by the federal government, right now you can only seek PVP protection for hemp plants. I've called the facility in Colorado. When I asked about depositing cannabis, they laughed for a very long time before answering. So sorry to interrupt. So even if there was a UPOV filing, for example, for an international depository, there's this additional requirement for a local federal sort of seed deposit, and therefore, even if an international deposit was made, you wouldn't be able to piggyback on that for a US federal filing? That is correct. That is correct. So for USDA PVP purposes, the biological material has to actually go to the USDA. And I'll say here that I haven't checked recently, but when the rules first came out, they were still even working out the details of how to handle deposits. So they instituted a holiday where you could get protection without having a deposit. Which brings just one last thing that I'll bring up here before we can get into, expand to other section, which is in terms of the utility deposit at a depository. It's important to remember that in the United States, cannabis is still federally legal, and so there are some difficulties in depositing cannabis, recreational cannabis lines. There are different depositories in the United States that will accept seeds and/or tissue. The most common deposit, and the one that is sort of least controversial, is that of hemp. But if you have a high THC line that you want to deposit, you either need to deposit it as tissue, and we've done that before, and we've developed it with the depository main, where we've made statements that it's not producing any cannabinoids at that stage, or there are also international depositories that have no qualms about the THC contents. And again, through some treaties between countries, a depository in one of those deposit facilities will be just as valid anywhere in any other countries that are signatories of those countries. And again, if someone has a specific question about that, I'm more than happy to provide information about that.
So I know again, speaking from the Canadian perspective, we don't have the ability to get a plant patent like you do in the United States. We can patent plant cells, but not the plant. We regarding plant breeders' rights or plant variety protection, So it's available. There's not too much controversy in terms. I mean, the most controversy as it concerns cannabis specifically is, proving novelty, proving uniformity, being able to show that it can benefit from the program, because you get 20 years monopoly if it's granted. It's actually very seldom used right now. In terms of active applications for plant breeders, right in Canada, there's maybe, excluding hemp varieties, there's maybe 10 or 11 ongoing applications right now, which is very, very surprising when you look at the extent to which the industry has expanded in Canada. So just an interesting sort of disparity between the use of a tool and the fact that no one seems to be able to bite on it for the moment. Have you noticed in the US some similarities?
Very similar, and I think I can explain that. And I'll just say one thing, because I know that there's an ex-colleague of mine in the audience. There are also design patents that are available, and that's not my area of expertise. But for example, if you have, we've done for extractor equipment, you can get a design patent. But to answer your question, Jason, so we have noticed a great preference for utility patents as opposed to PVP protection. The only exception to that is in jurisdictions where utility is not available or less available. And so one of those would be Europe. And we can talk about differences in different jurisdictions. But I would, if I'm recommending to a client, I would recommend utility. Again, for two reasons. One is that when you're looking at PVP, you are limited to hemp. And you really, they run the plant through, I think, stringent DUS testing. So it has to be distinct, it has to be uniform, and it has to be stable. And the uniformity for non-plant people is that when you grow a field of the plant, of the variety, they all need to look the same. And the stability means that generation after generation, they need to look the same. And they look at very detailed metrics of that plant. And I'll say that in general, the cannabis germplasm space has not gotten to the point where, compared to, for example, corn, where you can grow a Monsanto line for 5 years and it will look exactly the same, and you can have miles of fields, right? If anyone has driven through the Corn Belt of the United States, you can see from the highway miles through, right, one row of corn. And we just don't have that level of stability or of uniformity in the United States. And so I think there's a lot of concern that if there's even small variations, that that the application will be denied. Now, utility also wants it to be relatively stable and uniform, but you get to make those statements. It's purely based on applicant provided information. So we've provided pictures of fields where it looks pretty good, and that's been good enough. And then the second reason, again, is that PVP protection has those exceptions for farmers saving seed and for the ability to breed varieties. And so again, clients are usually adverse to allowing others the ability to breed with their valuable genetics. And there is no such exception as it relates to utility. And you can sort of craft strong protections via your license agreements to avoid selling the variety and therefore exhausting your patent rights.
Sure, and again, we'll get into it because in the interest of time, we'll sort of pepper in these concepts in and out. But of course, the idea of, if you can't get a legislative monopoly, you can get a maybe commercial monopoly through commercial terms, licensing terms, and things like that. So we've noticed that a lot as well in the cannabis space. How if there's a blind spot from a legislative perspective, well, then it'll get patched up contractually, and you kick the can further down the road to see how that's going to get interpreted. Because as you know, let's say, for example, when you have a penalty clause in a contract in a jurisdiction that doesn't necessarily allow for that trade to occur, and you're asking for a court to give grant the penalty that's recognized by the contract, you may be in an interesting situation to as it concerns the validity of the contract, depending on the form that you're in. But let's push that further down. And I guess maybe with the leading question, and then I want to list if you've seen this in terms of maybe some patent filings that may have come across your desk as well. But if someone is looking, for example, for an opinion in terms of were there any other enabling disclosures made, for example, with regards to let's say an extraction technology or an extraction technique, I would imagine that you would agree that such an opinion should consider industries that are not only peripheral to cannabis, but maybe involve, food, agriculture, cosmetic, pharmaceutical sciences at large. Is
I
that
actually
something?
agree. I personally, and this is in the interest of full disclosure, I personally do not have a technical background. I do a lot more of the work that I do on litigation counseling. I do coordinate the patent practice that we have with experts in our firm. But you're correct. I mean, the way to go about these issues is considering those peripheral industries as far as how it's going to be looked at upon being examined by the patent office.
Perfect. So we have this client who has an extraction technique, has plants that it believes has novel properties that will make for great dried flower that we sold as a adult use product. They want to commercialize it, they want to market it. There's a trademark that's going to get slapped on there. Okay. They want to market in Germany and in the US and in Canada. So what are we going to do here? Margaret, Nicole, how do we manage this client? I guess maybe Margaret, are there any considerations that this Canadian client needs to have before entering or deciding to enter Germany?
Yeah, maybe I go a step back just to give you an insight what the legal situation is with cannabis at the moment here in Germany. So you might know, since 2017, medical cannabis is legal in Germany. Since then, I'm handling medical cannabis trademarks here. CBD is CBD is not regulated at all. Let's say it's a gray field, but the market is booming. So you get CBD products all over the place in pharmacies, but also in drugstores. Actually, when you can eat them, they're actually not allowed. However, you can buy them here. We don't have the novel food. It's not through yet, the application as a novel food, so we have to wait here. However, the market in CBD is booming. Recreational cannabis is still illegal, even though the new government promised to legalize recreational cannabis in Germany, which is great news. But so far, that will take a long time, I guess, since we have it all regulated. So for now, it's still illegal. So, but now to your question, how to help your client who is located in Canada, you said, and who wants to have worldwide protection, or at least in Europe and Canada and US. So that's a typical case. A lot of my clients, they actually come from Canada. So with a few years ago, Canada got member of the Madrid Agreement, which is so now they are able, Canadian companies are able to use the Madrid system for protecting their trademarks, so-called international trademarks. So they need a base trademark in their home country, and then they can expand it worldwide. They can expand it through the whole European Union or specifically Germany. So that's what we see is now for 2 years or 3 years, the common way how they do it. However, and you all know that because you all, at least two of you are trademark lawyers. So, however, I just want to point out some specifics, which I sometimes tell my clients. So if you need a trademark protection quickly in Germany or in Europe, then maybe you don't want to choose the Madrid system, because that takes at least a year or even longer until first you need your base mark, then you file it through Geneva. That takes a few months. And then, however, it takes 1 year, 1.5 until you have your trademark here in Europe. So that's, if you need it quickly, it's better just to go directly to the EU trademark office in Alicante in Spain, or to national offices. If Germany is a very important market for you, you go to the German Patent and Trademark Office. So that's no problem. It's just a budget question, I would say. And the other thing, and you already pointed it out, Jason, is about the description of the goods and services. Even though all those countries we're talking about are member of the NIS classification, I see that the examiners are handling them very differently. So in Germany and Europe, we have a very broad approach. So you can use the broad descriptions like pharmaceutical preparations dot or cosmetics dot. However, when the same description, even though it is one of the terms from the NIS classification, are rejected in the US or Canada, correct me when I'm wrong, there I see you need more specific terms. It's too general. You have to actually describe what kind of cosmetic or what kind of pharmaceutical preparation. So, and at the early stage, a lot of clients, they don't know what kind of, in the cannabis field, there are so many instruments apparatus you need, or cosmetics, do I need gums or whatever. So it's easier to get a broad protection here in Europe. So that's another reason why maybe it could be wise to go directly to Europe and get your trademark, not through the Madrid system, because the Canadian based trademark will be very narrow. It has to be. So,
right.
Yeah.
Exactly. And you find that that creates an issue because of the broad descriptions with other traditional industries, because if you're saying pharmaceutical preparation, then there's a confusion risk, right? If there's another, let's say, traditional pharma company that has a non-cannabis based product in Germany, for example, have you started to see issues like that where because
in Europe and Germany, it's a bit different because the examiner, they never examine or look if there is a confusing similar trademark. So you get protection even if there is an identical trademark, identical goods, yeah. Because it's a different system. So here it's the trademark owner with a prior mark, they then have to oppose the mark. So you get your trademark, it's quite quickly registered, but then after the registration, we do have the opposition procedure. And so there are these circumstances where you do have identical trademarks, and then they have to deal with that in the opposition procedure. So all the questions about confusing similarity, about the goods and services or the trademark itself, it's not within the registration process.
No, of course, but I guess, sorry, I'll say it differently. Did you notice any cannabis specific issue with regards to either obtaining a trademark, or maybe there's a third party issue regarding confusion on opposition or even on infringement? Mm-hmm. Have you started to see any of these issues come up that are cannabis specific?
So far, because I mean, the market is so new. So the decisions we do have here are more about the registrability. Is it descriptive, or does it infringe morality aspects? So there are hardly any decisions about confusing similarity or infringement. Yes, okay. But yeah, I mean, and what we have so far we only when it comes to the description of the goods, only medical cannabis is allowed. I mean, because only that is legal so far. So at the very beginning in 2017, I mean, at the beginning, the examiners didn't know, so they rejected everything, but that's a long time ago. Then only class 5, which is pharmaceutical preparations, were accepted. But now we see that you do get cannabis trademarks in all other classes for sweets and beverages. And so even though, and not medical, I mean, naturally, it's not class 5 goods, it's other goods, so it's not medical, but at the moment, it's no problem to get it. And which is good. We saw that was an involvement here. I can point that out. I had one case before our highest court, the German Federal Patent Court, and then they pointed that out. What is this? It was in class 3, which is cosmetics, but not medical cosmetics. So they said, the examiner at the German Patent Trademark Office, they actually made a mistake because this is all illegal. And but at that point, we already had this European court decision from the European Court of Justice, which said CBD products are not narcotics any longer. So I explained them that, but you see, it's there. At the end, we withdrew the whole proceedings because the client didn't want to go through it, unfortunately. But I think I had really good arguments on my side, because the Federal Patent Court, of course, has to follow whatever the European Court of Justice says. But you see, it's still conservative. Yeah.
Sure. So that's it. So there's a commercialization requirement that attaches itself to the trademark in Germany, at least. In other words, if it's not lawful to, for example, sell recreational cannabis, you can't obtain a trademark for.
No.
Right. Okay. Interesting. So then, just to I guess round up with regards to this client, then would you recommend mostly a filing under Madrid or otherwise, or under the European system,
Yeah.
or a national filing directly into Germany if only class 5 is available, for example?
Right. If there is no time pressure, or if they already know exactly what they want, then budget-wise, it makes total sense to start in Canada, get your base trademark there, and then file through Madrid and get all the countries you need, because it's much cheaper. You don't need attorneys in each country if you don't face any problems. You only have to renew one trademark in 10 years. You don't have to renew you don't have single trademarks everywhere in the world. So it's wise, but it really depends on the case. But in general, yes.
Perfect. So I see Nicole put up her hand first, and I was going to throw to you anyway, because I said, okay, so I think I know what we can recommend over for the European Germany side, but I saw you lift your hand, Nicole. What do we do here?
Yeah, so in the US, unfortunately, cannabis is still unlawful federally, and so you can't get federal protection for anything that touches the plant, except for some hemp products, because hemp is lawful under the Agricultural Improvement Act. So you can get through applications for products that are plant touching for CBD for cosmetics. The Food, Drug, and Cosmetic Act prohibits anything ingestible. So no foods, no beverages, nothing that has CBD in it that you can ingest. Inhalables and topicals for cosmetic purposes are the only things that you can get federal protection for at the moment. So that kind of throws a wrench into the strategy of filing through the Madrid protocol. It's great if you can get them elsewhere. You can't get the same things that you're applying for in your base registration in Canada in the US. You almost have to file nationally. And you have to change your strategy up. For the US, we typically recommend starting with an application for ancillary informational services related to cannabis or CBD, because those are lawful free speech situations that you can get protection for, no problem, while you kind of figure out what to do about your products. Whether you actually do want to do CBD cosmetics, that's something you could then file for protection. But you do have to prove use before you get your trademark registration in the US, unlike many other jurisdictions where you can just get the registration and then deal with the use later. So if you're applying in the US and you're a Canadian company and you're applying for the CBD cosmetics, say for example, before you get your registration, you're going to have to prove use. And if you're filing an intent to use application, you do have some time, but you really have to think about your commercialization strategy in the US if you actually want to get your registration. So that's a big issue that we see from Canadian clients that want to go into the US. You have to think about what your next steps are, because you can defer, you can file extensions on your intent to use application, but at a certain point, you either use it or lose it, basically. And you need to think about those strategies beforehand and whether that's a viable commercialization strategy for you. The other thing I will add to the issue you brought up regarding jurisdiction or other non-cannabis goods being an issue for cannabis goods, we've actually seen where there's in the situation for edibles and regular food products. So for example, in the UK and EU for us, the trademark offices, so we've had oppositions in this area, and the UK and EU trademark offices have basically treated any goods filed in class 29 or 30, regardless if they're, say, with cannabis in them, they've treated those as food products. And in connection with likelihood of confusion issues, we've tried to argue that the cannabis infused edible was not a food. It's simply an ingestion method. It's not a food in the traditional sense. You don't consume a cannabis edible to satisfy hunger or for nutrition. It's just a delivery mechanism. And you certainly can't eat a cannabis edible as you would normal food. I can't sit there with a bag of potato chips, cannabis infused potato chips, and just eat the whole bag. You have to be, quite careful about how much you consume. So the purposes are different. And you also, the channels of trade are different. Also, you can't just buy medical cannabis products, anywhere. You have their specific dispensaries or pharmacies for those products. But if they're in class 5 or in class 30 or 29, if you file in those classes, they're automatically treated as foods. And those arguments actually haven't been quite successful. I see, Margaret, you have your hand up if you want to kind of jump in there.
You just answered it. I was wondering, because this is what I would say, these arguments would be hard to be accepted. Yeah. And you just answered it. Yes. Yeah. It's that is the system. As soon as you're in class 29, you're food. Class 30, you're sweets or salty stuff. So it doesn't matter what's inside. Mm-hmm. But in trademark law, let's see what in 5 years, when the market is and the judges actually have eaten it, they all don't know yet what it's like. Then maybe the law changes, but now it's not a real argument. I agree.
Yeah. Right. It's been a difficult road, and for us, we understand, like, we just see how regulated the dispensaries are in the States, and how difficult it is. You can't really get a traditional food product inside a dispensary as well. So we see that division, that the likelihood of confusion, but it really comes down to what's in your application. And so it might make more sense to file in class 5 as opposed to class 29 or 30, even if it's, a recreational edible product. It's still for some sort of not traditional food purpose. And so it might make more sense to go the class 5 route, so you don't get stuck with these issues, because there are a lot of food companies. Food and beverage are a very, very large class, and there's a ton of trademarks out there for food and beverage products. So it might make more sense to file in class 5.
Yeah, we've noticed, and honestly, I saw we'll get right to you. I saw you've been putting up your hand, so that this sort of ping-ponging around in terms of choosing your classes and having it select for and almost make your bed in terms of what kind of arguments you're going to present is interesting, because then let's say on the other hand of things, let's say if you're looking at something that's federally regulated, like a form of like pharmaceutical or medication or something, you may be stuck, by admitting that you're in the class 5, you may be causing other problems that you wouldn't have necessarily had otherwise, and so on. So you always have this sort of spinning plate scenario when it comes to picking and choosing and seeing what, because at the end of the day, your burden is the likelihood of confusion. And, if you pick outside of a class, well, then you may inherit other issues as well. So that's it. So, and just quickly before we get to Honolulu, so then in terms of state applications for a state mark, what does it look like there?
So it depends on the state. Typically, you have to have commercialization in the state before you can get a state registration. So that's a huge issue for a lot of clients that, maybe they have deals or they want to go into that state, but they actually have to be selling in the state before you can get the registration. You have to submit at the time. There is no intent to use parallel for state applications. I believe Washington, you can reserve a mark for like 180 days, but that's pretty much it. Typically you have to submit a specimen of use along with your application for state protection. Also, with regard to whether something is federally lawful, like for example, CBD edibles, while they're not federally lawful. Most states also follow the Food, Drug, and Cosmetic Act with respect to edibles. There are some states like California actually just recently decided to go against that, and they will allow CBD infused edible products, but most states still follow the Food, Drug, and Cosmetic Act. So you kind of need to know which states have kind of gone against the grain in that way. But where cannabis is state lawful, you can get registrations for cannabis products in the states like California, Washington, Colorado, all of those. Whether you need to decide if it's a medical state, that you need to say that it's for medical purposes, that's also a consideration as well. But that state-by-state approach is great if you're in those states, but that's not, I think, the majority of our clients.
Okay, understood. Okay, and just to wrap it up on that, is what we've noticed is, at least from the courts, is that depending on the situation you are with regards to confusion and the different classes, let's say it's food or otherwise, is that if you're in a clearly counterfeit situation, for example, if you have a well-known food brand that's clearly being counterfeited by an equivalent, let's say black market cannabis product, the courts seem to be much more lenient in terms of expanding, those descriptions or those categories to include other things, even though from a regulatory perspective, like a food may not necessarily be a food for cannabis, but we've noticed that they're more lenient when it comes to that. One was you were saying, or you wanted to add something on top of.
Yeah, just a couple of points. One, going back to what Margaret was explaining, and one going back to Nicole's point on the analysis of different classes. I totally agree with Margaret's view on, go through Madrid, if you have the time, et cetera, et cetera. The issue that you would face, for example, in this hypothetical case in Mexico is similar to what Nicole was saying. As far as use statements, you do have a 3-year window to start using your mark, and then you have to file an under oath statement here that your mark is in use. And otherwise you will lose your registration. Some people lie about it. You certainly don't want to do that, especially around this industry. But that's something to consider as far as the specific jurisdictions. And I was wondering, because to Nicole's point on thinking about which class you're going to file, and this mix between edibles and class 5 for pharmaceutical products or healthcare products, you may face some problems. At least we've had some analogous cases here where a counterpart in litigation was using a mark. The mark was actually in use, but it was not being used for the precise products in the class that it was registered in. And we got a non-use cancellation declaration. So we actually revoked that mark because it was not being used in the class that it was registered. It was being used for something else. So that's an interesting consideration. I'm not quite sure how it works under U.S. law by any means, but I do know that, for example, if you have a food product that does not fall within any of the categories that are regulated for healthcare, and you only registered your mark in class 5 here, you could have a risk of losing that mark for lack of use, just for straight up lack of use, and having somebody else registering a health product that was classified, say as a supplement, for example, in that class. So that's just something to bear in mind there.
So very direct, clean cut approach to, expanding the client's trademark portfolio. We heard from Marcello before with regards to patenting or at least obtaining some form of a monopoly as it concerns an innovation or the genetics. Okay, so we have the beginnings of a portfolio. It's getting together, and we're doing the best we can with the moving parts that we have. But then what about enforcement? So how do we sell this client on the added benefits? Sure, commercially, when you look at the press releases in the cannabis industry, there's a lot of accentuation or a lot of focus put on the an IP purchase, okay, IP asset purchase. But what does that give you? What can you do? What limitations are there, and what specific challenges really apply to cannabis-based innovations when it comes to trying to enforce this. And judging by the shaking of her head, I can see that maybe Dr. Mitra has maybe some wisdom to provide on that. And so what do you have to say to this client when they're asking, what do I need to know about enforcing my portfolio?
Thank you, Jason. Yes, this is actually a question I've often had to discuss with clients. And what we are doing in the cannabis space is take the traditional risk-benefit analysis of patent litigation and apply the specific considerations that come out of the cannabis industry. So let's break this down step by step. Pre-litigation due diligence is absolutely critical. Now, you have a patent, you think somebody's infringing it, that gives you the right to act against them. And the question I have for the client is, what's your commercial value over here? Do you feel that they're taking away your market share? Do you feel they're expanding, because of their presence in the market, you're not being able to sell the product? And sometimes the case is, yes, you have a patent, but the commercial impact doesn't justify a multi-million-dollar bill that's necessarily going to follow. So there is a strong business decision, business consideration that should be taken up front, because patent litigation is expensive. A $1 million+ bill is not unusual. So, okay, so you have a portfolio and you feel it is important for you to enforce it. It's important for your brand. It's important for your space, if in the marketplace. It's important for how you develop your business in the future, because that's how you're going to sell it to investors. So let's sit down and talk about the basics. As the plaintiff, as the patent owner, you have to have at least a prima facie case that it's infringing. So the first analysis is, okay, let's take a look at the scope of the claims that you've been granted. And what is my infringement analysis? That's going to go into the complaint. And do we see any weaknesses over here? For example, have you made any statements during the prosecution that limits the scope of your claims? Are there terms in the claim that will lead to claim construction that may not get you the outcome you want? And this I point out because if you recall, in the GW Pharma and the Canopy Growth case, the main issue was claim construction, and after an unfavorable claim construction, unless the Federal Circuit reverses, there's probably not going to be a lot going on over here. And often people in the business owners in the cannabis industry may not appreciate the nuances that go into this. And we also take a look at the patent and the prosecution history with a very critical eye, in the sense, what if I were sitting on the other side of the table? What would I do to break this patent? What would I do to invalidate it? Is there other prior art that I know that I could cite and show that, well, the patent office did not consider this? Is there something that gives rise to claims that there might be inequitable conduct? So these are we kind of test the strengths and weaknesses of the patent that we are about to assert. Now, I will say till date, no court has thrown out a cannabis-related patent on grounds that this is an illegal industry, which is great, because a patent really gives you the right to exclude. It doesn't necessarily say, I am practicing this. But it is an important consideration, maybe not at the point when you're filing your petition, but downstream. Damages. What's going to be your damages story? Where are you going to find an expert? Maybe the state legalized in the last, maybe 2 years ago. Maybe the priority date is, 3 years ago, but the real expert in this business has been doing this for 10, 15 years in the underground economy. So will you face challenges over there? Another question that's interesting, and I don't believe has ever been addressed, is when the inventor gets on the stand and testifies to working in this, are they admitting to some kind of a crime? These are questions we ask, but these are not questions we have answered. I can see Marcello has raised his hand. Perhaps you'd like to say something before I continue?
Yeah, so Dr. J, I think this is a super interesting topic, and one that I've researched both for the firm, but also personal interest. And I think that there's two issues. One is that it's important to note that at least patent law is federal law. So you're going to be in a federal court, right? So
Yes.
cannabis is still illegal federally. And so Dr. J's comment about wanting to testify is, I think, very relevant here, but also understanding that I don't think any client necessarily wants to be, undergo discovery, right, of their cannabis business and air their dirty laundry in terms of how they've reported their taxes, what they have grown, have they complied with all the right state regulations. And so for that reason, I think that cuts both ways. One is that there's an aversion to going to court, but also maybe there's on the part of the plaintiff, but also on the defendant. And so based on that alone, that might get you some results, right? So even if you're not necessarily likely to prevail on the merits, you might get someone to get out of your way to avoid going in court. In terms of the plaintiff, one practical thing to consider is perhaps having the IP owned by an IP holding company that has nothing to do with production, no plant touching business, right? So you want to present a very clean plaintiff would be, one suggestion there. No, sorry, go ahead, Dr. J.
Actually, I was going to touch on the discovery issue because one of the challenges we faced is perhaps the document retention policies are not what we would like to see. I'm looking for documents dating back from when you first started working on this. What is your invention story? I may not be able to find those documents because a lot of companies do not have a robust document retention policy in place, especially in the early days when they're first developing this. So what Marcello said is about this cutting both ways is a risk assessment you have to do upfront. You have to know what is your weakness. If you're concerned that there are certain documents missing that might pose a challenge, if there are certain disclosures that you're obligated to make, well, there is a protective order, and that should be negotiated very carefully. But is there something beyond that we need to consider? If this is going to go into, if you're going to, often in a patent litigation, the defense side will file what's called an IPR, an inter partes review that is before the PTAB, and that's where just the validity is challenged. Can you make certain stipulations upfront in this, protective order, in the scheduling order, how you handle information that is being exchanged, so you're being able to keep things under a confidentiality designation and not necessarily sharing with the public. So these are very important elements. And I will just add one more thing before I hand it back to Marcello, is that when you're making an infringement case, you have to have an argument that you put in the complaint so you don't get kicked out on a motion to dismiss because you've inadequately pled your claims. Say your allegation is that my competitor has an apparatus for extraction that is infringing my patent. That's great. How do you know they are? What, are you relying on just public disclosures? Did you happen to visit their factory and see something that leads you to think? I mean, look, if it's a gummy bear or it's a packaging material, we can just go to the store, buy one, and sit down and make the analysis. But if you're talking about certain types of equipment which is not available to the public, how do you make your case? So I think Marcello interrupted you. If I could just,
well, actually, it's interesting because again, it's almost like we're reliving two certain challenging cases we've all had in other industries as well, because that disclosure issue is prevalent anytime you deal with any form of methodology. Where
100%.
Where do you? But I saw before we get back to Marcello, I know Manolus, you had a comment too that you wanted to add there too.
I think it's a bit more of a question for you guys in the States and maybe in Europe. One way that we've enforced patents in the past here, especially around pharmaceuticals, has been not only suing the competitor, but also suing the government for issuing approvals or licenses, trying to get those approvals or licenses revoked as they are approving, similar to what happened in the US, the discussions in the 80s around the Orange Book and Hatch-Waxman and all those things, but challenging those approvals and also challenging purchases by the government. So I'm quite sure that whenever we do get a robust regulatory framework where you have some cannabis goods licensed by the Mexican regulatory agency, and you also have a patent around them, you'll be able to try not only to sue the counterpart, they've sold this and they're causing my client harm, but also to try to sue to get their approval revoked. So my question is, in addition to the points that Dr. J was making, as far as thinking about these issues in a civil claim where you're challenging somebody else, have you given any thought, or has it come up where you're not just challenging that, but you're also trying to revoke your competitor's approval, or trying to, if the government purchases these products at some point, trying to challenge those purchases?
Yeah, I mean, I'll jump in real quick for Canada, just because we have this, federal market. Since the federal government doesn't approve products specifically, they give licenses to a company to operate. We don't see any of this direct, even though there is some bubbling litigation with regards to Health Canada and certain matters, primarily also on the excise tax issue, but that's different. We are starting to see retailers getting pulled into the mix, and some of this retail at distribution level is government monopoly. So it traces back to your thing about the government being sued directly, and they are right now naive to this completely. So if you're starting to see demand letters being sent out to government monopolies because they have for distribution, whether it's a trademark issue or patent issue and so on, and they're by and large primarily blindsided by it because it didn't factor into their logic when they put together the. So to your point, I foresee that it'll probably be a tool that will be used short term until people contractually sort of plug that up and shove responsibility onto third parties for that.
Just to bring it back to the conversation we're having with Dr. J, and I do think that people have to get creative with their suits. The second element that Dr. J alluded to, but we haven't really gotten into, is aside from all the traditional considerations and potential the risks of disclosure that come from a federal suit, there is still, I think, an open legal question as to whether cannabis patents are enforceable, right? So whether you can enforce a patent on something that is illegal. And I think the issue mostly centers around the calculation of damages. And we've seen this, for example, in the United States as it relates to bankruptcy, where cannabis companies do not have access to traditional bankruptcy laws. And it has to do a little bit with the unclean hands doctrine. The idea being that someone that comes with unclean hands, meaning having done something illegal or having been involved in the cannabis industry, then coming to the court for help. And I think that there's a lot of unanswered questions, but the way I view it, and just very high level, and I'd be happy to hear, I'd be interested to hear what Dr. J says, is that I see this more as a gradient, and that there are some patent claims and some defendants that are more amenable to a suit. If you have a claim, for example, as Canopy did, to a general extraction method, that it's not necessarily on the plant itself or on anything illegal, I think it's easier to enforce, and particularly against a defendant that is not doing anything illegal and has an approved product, right? I think Canopy knew very well when they chose
absolutely
W for the suit. So that would be one scenario, as opposed to suing someone that is, working illegally on a germplasm, right? A cannabis plant type claim would be on the other extreme, where you would face difficulties. And the issue is that you would be almost, if you're looking for an injunction, you may have more of a chance, all right? But when you're suing and it's costing you a lot of money, you're mostly going after damages. You want cash. And I think it'd be hard for the court to say, all these funds from the cannabis products that you've been selling illegally under federal law, I'm going to order you to transfer them to the plaintiff. So there's still some issues in a pre-federal legalization framework that we're working on that I think we'd have to address. And so if you get, for practitioners here, if you get a demand letter, it's a conversation to have with your client. If you are the patent owner, it's something to talk with your client and say, are these the right claims? Is this the right defendant? Should we go after different claims? Can we get them another way? Lawyers are creative, so I believe there's a way forward, but I think understanding that potential limitation is good to know.
No, I absolutely agree with you that there is a gradient, and the Canopy growth case was very important because it was on the gradient where we could probably argue this is a legal product that's being sold legally through the, that's being sold following approval by the FDA. And that also places a lot of pressure on the defendant, because this is a product, if Canopy had prevailed, what would it have done to GW's business? I mean, there was like, what, 1 year left on the patent when they brought the action. So it's actually for me, one of the most critical conversations to have with the client is, what is it that you're asking for? And have you considered the impact this would have on your own business and on the industry? Let's talk about a different situation. One is where the patent has multiple uses that's not necessarily related to the cannabis industry. For example, you have some kind of a childproof packaging, right? Now you can use that because you don't want your kid to smoke pot, but also because you don't want your kid to go through your private papers. So what is it that you're actually working on over here? Another situation which has come up, and again, I'm not sure there is a good answer, is when the product is entering across borders, or at least the infringing product is reliant on something coming across the borders. Maybe it's being practiced in the United States, but critical components are coming across the borders. What do? Can you go to the ITC? Can you go to the CBP and stop the product from coming in? Again, these are creative solutions, but the question is, who are you enforcing against? How are you going to enforce it? And what are the considerations that you've look at in terms of your industry that makes it, a good idea, not so good idea, or a terrible idea? And just to add one more thing over here that I kind of keep in mind is not just people arguing that the defense coming back and saying that you're selling a product illegally, which is unique to the cannabis industry. There are a lot of traditional questions that also come up. For example, if your patent is not likely, or if I won't say if then we can't go to the court at all. But if the defense is there is an antitrust action over here, because you are enforcing a patent that is otherwise unenforceable, you're trying to keep legitimate competitors out of the business. Well, how does that antitrust claim work? What is going to be their argument? What is going to be your defense? Because you might wind up having to make certain concessions to defend yourself against an antitrust action that's not going to help you in your patent case. So Marcella, I'll toss this back to you.
So I think that's a great summary, and we don't know a lot, so we can't give any super definite answers, and certainly not this time period. But there's one thing that I would like to point out, is that we're talking about questions about enforceability, but patents have a lot of value for a lot of different reasons.
Yes.
And so as we talk, there is a real threat. There's ways to push people because they don't want to go to court. But also, we found that patents are super helpful when companies are trying to develop licensing schemes across states. It provides sort of an anchor to your technology. It raises funds. It helps document your work and ensure that at the end of the day, no one can patent on top of you because it publishes. And of course, we have to remember that there's a 20-year span on these patents. And so the legal issues that we're facing today may not be facing, and I'm sure this is true for, as Margaret mentioned, for trademarks, right? I think a lot of our clients, probably appropriately so, are taking the long view, and that legalization is a train that's not likely to stop time soon. And these assets may have significant value, not just now, but also in the future.
So exactly, that's a good jumping on point, just in the interest of time, to say we have traditional tools to our disposal, and a lot of us got comfortable with those tools. There's a lot of questions that are primed to set precedents because basically maybe things aren't completely harmonized, and that's the situation that we're in right now. But the moral to that should be, if you have the right case with the right client, you got to give it a try, because if in the absence of which, that means there are no tools available and there's no recourse, it doesn't seem like that's an acceptable recommendation that you can give to a client, right? Just say, well, we don't know, it hasn't been done, and well, you're out of luck. And it seems like there's an expectation that things are going to evolve to get around that and eventually be completely harmonized. So with that in mind, obviously it's always know your jurisdiction, know what you're getting into, get the proper counsel, and understand your risk profile. So and that was something that in Canada was hard to get clients to accept, is that they were kind of got comfortable. I mean, there's plenty of other issues, and Canada's definitely not a perfect example for, a regulated market. It's just that we had, questions like enforceability and damages and who your expert is and things like that. We don't really need to ask those questions anymore. We just need to find these people, and that becomes a interesting challenge. But now we're at the point where we have to unfortunately kind of wind down the conversation. We're at maybe 10-2. I don't know if there's questions or not. Clearly, each and every topic that was introduced can be in and of itself and a standalone conversation. Okay, but we have this client who is itching to want to go forward with its project. You have maybe 2 minutes to tell the client, with regards to what what is the absolute lesson learned? What is the thing that they need to keep in mind with regards to either protecting their trademark, dealing with an innovation? We broached trade secrets. Maybe you want to mention it too, go for it, but maybe try and limit it to 2 to 3 minutes each. I'll go in the direction that I have in my screen right now. So that goes to Margaret first. If you have some wisdom in terms of, that you want to tell this cannabis client in terms of the strategy or some lesson that you've learned, what do you want to tell them?
Right. So get trademark protection. Yeah, and the way you do it, it really depends the case you brought forward. And absolutely, Nicole, for US clients, there is not that option probably to go with Madrid. So you just go directly, which is easy, really. I mean, we have a lot of US clients just going directly to the EU trademark office. And talking about cannabis trademarks, you have to know, but what I hear maybe in the US, it's even worse, I don't know. They're still conservative examiners. So whenever your trademark bears something like weed or some kind of description for cannabis, then it will get rejected. So when you think about your brand name or your company name, you have to keep that in mind. So we do have really well-known companies, they don't get protection here in Europe for their brand because it bears that name or a description of it, because it's against public policy and accepted principles of morality. So yes, I think that's, from a trademark perspective, very important.
Perfect. And also maybe for completely pushing it for another time, but this interesting juxtaposition between, tradition that was, or at least things that come from the legacy market, like the naming of varietals, what can you do with that? How does that work and all that? These are obviously things that need to be peppered in and kept top of mind. Subject for another time, but for those participating, just know that when we're talking about branding, we're not talking about variety naming and the legacy names. That's something that you need to consider keeping distinct. So next is Nicole. Nicole, what wisdom do you have to share or lesson learned?
Well, I guess piggyback off of Margaret, get trademark protection, but be very careful about what you're protecting, because that has a huge impact on the validity of your trademark. And I always say a trademark registration is just paper if it can't be enforced or if it's not valid. So it really does nothing for your business unless you can use it in some way and it can be actually of value to you. And in that vein, be really careful about the use requirements in various jurisdictions that you're protecting your mark. I mean, obviously in the US, be careful about use because you have use to get your trademark, but then also be careful of use, like in Mexico, where you need to file a declaration of use after a certain amount of years. And then be careful of use in other jurisdictions where you get your registration, but maybe your registration is vulnerable to a non-use cancellation in 3 or 5 years. And when I talk about non-use cancellation, I think we talked about it a little bit, where a third party can petition to cancel your registration based on you not using your mark within a certain amount of time. And so when you get those 3 to 5 years in your registration, maybe think about refiling, or whether your trademark's vulnerable, or whether you just need to be kind of constantly evaluating your use and what your plans are going forward, because trademark rights are use-based rights, and you can't just sit on trademarks just to have a portfolio. You really do need to keep use in mind. So I think that's the the biggest consideration is this use and where you're using it and where you intend to use.
Definitely, and the idea that maybe sitting on the register while prosecution happens, and getting at least being there, so that if someone comes afterwards, at least you're first up in terms of eventually showing that use and so on. It's better than nothing, and it also reserves your place there. So absolutely. Juan Luis, you're next.
Thank you, Jason. So I think there's a very, very steep divide in how you think about my country as far as cannabis is concerned. On the IP side, we're pretty standard. So you'll be able to get a patent, you'll be able to get a trademark. You'll have the same issues that you come across your jurisdiction of origin. The issues that Margaret was mentioning about certain words, you'll face those here. Your patentability issues, you'll face them here. We unfortunately still don't have federal legislation outside of some very limited rules surrounding medical products. So that's going to be a whole set of different issues, and will cross over with cannabis. But on the IP side, it's a pretty standard line of thought.
Yeah, indeed. And again, like I said, we're limited to 90 minutes. We could have probably done another hour or two, because there's a lot being left on the table there. So Marcello, closing words before we throw it to Dr. J.
Yeah, so I guess the message that I would leave you with is, I think patenting is pretty standard across the board, even when it involves cannabis. There are some issues that you run into when it's cannabis. There are some issues that you run into when it's a genetic product that you're trying to patent. What I would say is that it's very important to get good counsel, because these small things come up and usually they require preparation. So it's important to have good counsel, and it's also important to have counsel that understands the technology. Just really briefly, examples that come up, right, is examiners may not understand the difference between THCA and THC. And if you have like a claim limitation based on THC, they might cite THCA and think, well, it's the same. And then you can say, well, when it gets decarboxylated, it's lower. The other thing is, one thing that comes up that's more unique to cannabis is, when you're prosecuting, the prior art that you're facing is usually not, Nature article, right? It's crazy stoner 101 posting on a forum. And that is prior art, and it will be cited against you, and you will have to just hold your smile and answer the examiner. But to that, I would say this is a very much an elbows out kind of prosecution. You have to feel comfortable challenging assertions made in the art. And so again, a really good counsel will make a big difference. A patent is not a patent. It's like you can always get someone to do it differently, but it's like getting a tattoo, right? You want someone that's going to do a good job.
And I'll piggyback on that a little bit before throwing it to Dr. J, is that there's also a double-edged sword, because a lot of us, it's a multifaceted practice in many fields. So you need to be aware that as examiners are becoming more and more, that's whether in trademarks or in patents or whatnot, getting more familiar with cannabis publications, depending on how you use it, you either want that familiarity or don't. So in terms of the argument that you're going to make, if you're representing a traditional industry client, you're going to say, well, look, what that prior art in cannabis either doesn't apply or it does apply, and so on, and create proximity or distance. So if on the one hand you're arguing for the cannabis industry to create distance with traditional industry, be wary that if you're ever on the other side, you may have to do the opposite. So you kind of have to, sort of know how to navigate that situation. And that's something that's coming up a lot in Canada right now, is that, how distinct is this industry really, and what was said in one context may not necessarily hold true in another, because you're now representing the other side. Anyway, but that also applies to other industries, but I wanted to make it known too that comes down and it happens a lot more often than you think. So Dr. J, final thoughts?
Yes, despite all the negative statements I made about the difficulties in patent enforcement, let me end with the positive note: patents are worth enforcing. Even with all the risks, those are the risks that you have to navigate. And that's why it's important to pick the right counsel as your partner, who can help you assess what is your risk while you're going in. But at the end of the day, it is your property. And as Marcello said, it's an elbows out area. we work hard to get the patents, you've invested a great deal into the patent, it's important for you to maintain your position in the industry using that patent. So the risks aren't there. This is not a traditional industry. People in this industry know that they're taking a risk. And it's important to defend what you have, taking into account the risks and being smart about it.
And the idea of risk is also, I guess, relative to how far you are with regards to legalization and
yes, absolutely.
Yeah. So on that note, I guess I see Chris popped up, which means I guess we're off the hook. Is that what that means? What does that mean?
Means we're coming close to an end. Yeah, I just a wealth of information that you guys were able to share with us today. I similarly am very, very curious about sort of the future of enforcement, especially with regards to patents. Picking up on something that Marcelo said around US bankruptcy courts and sort of their appetite for taking on cannabis related bankruptcy cases. I know that one of their sort of major hooks for dismissing those cases was asking a US trustee to be a custodian of federally illegal assets. And so I do wonder if there's a slight difference between a judge mandating divestiture of proceeds versus sort of having a US trustee actually take over custodianship of some assets that remain federally illegal. So super curious to see sort of how that plays out. Marcelo, are you aware of any enforcement cases that have dismissed on sort of the federal illegality grounds, or Dr. J?
So far, I'm not aware, or not in patents, not about bankruptcy. That I cannot answer.
Yes, in patents, in the IP space.
So I'll say, Chris, I am familiar with the case and the trustees, and I actually wrote a whole small treatise on this, and I was not allowed to publish it for reasons that we can't get into. But in terms of patent cases in the cannabis space, I think we had the Pure Hemp Collective, and that one seemed to proceed. The issue was never raised. So, I mean, that's not positive case law, and certainly was just at the district court, but at least it's something that was allowed to proceed. And then, of course, we have the Canopy GW case that proceeded. Again, there's some special circumstances, so we don't have a really clear indication. But if you're asking me personally, I think that if you have a smart counsel, a cannabis patent will be enforceable. Because there's otherwise you're allowing someone to escape a right just because they're doing something illegal. And there's lots of examples where courts have enforced patents against illegal things. For example, the coin stamping machines that you see, you put in a penny and $5 and it prints on your penny, that's illegal. You're defacing money in the United States. But there are patents on there and they were enforced. Now they got dropped and they settled, which is unfortunate for me because that was where I was going to hang my hat. But there's also defacing the American flag is also federal law. And we have patents on and design patents on different pants, right, with different American flag symbols. So there's lots of examples that a good counsel, I think, could rely on and convince the judge to assign damages.
I just want to add one litigation that's not being mentioned. I think there was a company called, it's more of a holding company called Gene Pool. I think they've brought an extraction patent proceeding against, I forget who the defendant is, and there is now an IPR pending on those patents. So it's definitely happening. And a lot of these cases, in my opinion, are flying under the radar. Sometimes I read about them because I happen to be searching for something else and the search pops up. But I don't see patent litigation going away in the near future because the product happens to be illegal.
Sure. Yeah, and I know that for me, it brings up nightmares around Erie doctrine, although I know that's for federal diversity jurisdiction. We're talking about question jurisdiction here. So I know that there's going to be some complex issues around looking through at the legality under state law in terms of calculation of damages. So I can't wait to have you both back to talk to us about calculation of damages and enforcement of patents once that becomes a little bit more right. So thank you again to all of our wonderful panelists.